Phil Holloway is a former assistant DA, joins us from Atlanta, Georgia. Phil, first time in your state. What are they up against?
Yeah, good morning, guys. Great to be with you, although I'm sorry it's on such a sad subject. You know, what you just saw was the initial appearance within, a short period of time, a day or so. Everyone who's arrested and is held without bond has to be informed what the charges are and what the range of punishment is. And of course, the judge corrected that because he's a minor. He does not face the death penalty. But the father, who we will see coming up in court later on, is facing different charges. Now, his charges are grounded in criminal negligence, which is something more than ordinary negligence. It's like an extreme recklessness or carelessness without regard to people's lives and safety. So it's very fact dependent. And right now we don't know all the facts, but the charges, the second degree murder in particular, he's got 2 counts of those, I understand, and each one of those carries up to 30 years and a minimum, I think, of 10, not including the other charges. So both of these individuals are potentially facing the rest of their natural lives in prison. I think law enforcement is still having to complete their investigation, but the criminal negligence aspect is very, very fact dependent. And all we know right now is that he's allegedly made this firearm available to his son. So we need to find out some additional details, but needless to say, the facts as alleged against both of these guys appear to be very, very damning for both of them.
There is an additional comment in that audio that we played, that newly released audio from the father and that police home visit from 2023. Just listen to this before Colin Gray, the father of the shooter, goes into court. Let's listen.
He knows the seriousness of weapons and what they can do and how to use them and not use them. So it's kind of a little bit of a shock. So in whatever y'all are telling him, please instill in him that if this is whatever or wherever this is coming from, it's no joke.
Yeah.
Like, it's no joke.
But we wouldn't be here if it was.
No, I know. And I'm telling you right now, we talk about it quite a bit. Okay. All the school shootings, things that happen.
Yeah, scary.
Hey, are you getting picked on at school? He is. He's getting picked on at school, and is everything okay? That's why I keep going up there.
Yeah.
Because you never really know, and I don't want anything to happen to him. So, yeah.
So, Phil, as I understand it, so then the prosecutors are looking at that, saying there was prior knowledge about this.
Yeah, so when I say it's fact dependent, that is one of the facts that is obviously going to be very key. If he had notice and he was on knowledge, he had advanced knowledge that his son may have made these kind of threats, and then he later provided him a firearm or access to a firearm, that's obviously, I think, what's driving the charges against the father. There's other things to consider, though. The investigation is going to have to determine, did he have more than access? Was he able to have ammunition? Was he able to access these things without adult supervision? Exactly how were any weapons stored? And what specifically, other than that May 2023 incident, what other information might have been known to the father? These are all going to be parts of the investigation. The judge just said there's going to be a preliminary hearing set for a couple of months from now. That's a more detailed exposition, if you will, of the facts of the case. It's called a probable cause or committal hearing. We will actually hear, if that hearing is not waived, we'll hear evidence from law enforcement under oath on the stand as to all of the facts and circumstances that justify the warrants in the case. And the judge will have to decide if there's enough evidence against the father and the son actually to proceed for further court proceedings.
It appears to me the most damning thing they said last night is that the elder Gray, meaning the father, knowingly allowed his son to possess a weapon.
Yep.
Yeah.
Age 13, age 14 now. We'll be back inside that courtroom in a moment. Phil, stand by. When the father is in there, we'll take our viewers back. Thank you.
All right, welcome back inside the law. I'm your host, Philip Holloway. This, of course, is the LawTube channel where we take you inside the real justice system to see what it looks like in the real world, and not just what you might think it looks like if all you do is watch the movies or even cable television. So from that introduction, you can tell obviously this show is going to be a little bit more serious in nature than some of the other ones that we may have done. But this is not intended to be. Let me just get this out of the way. This is not intended to be a discussion about hot button, oftentimes divisive political issues that surround these types of tragedies. We are taking this case that sadly is, in fact, in the news, and we're going to look at the law enforcement response. We're going to look at the charges that were taken by law enforcement. We're going to go through the elements of those offenses, and we're going to see sort of how this case is developing in the infancy of the court processes as it pertains to this father and the son who have been accused of very serious crimes. But the idea is that we learn something, okay? And so we're going to do our best to keep it focused on that. You guys in the chat, I mean, I'm sure people will be chatting about whatever in the world they think you guys want to chat about. Just please be respectful. There's a couple of Kiana and maybe some other moderators in there, hopefully things will stay civil, but we are focusing here on what we can learn about the real justice system. I know there's a lot of strong feelings about a lot of things related to this case, and probably most of those things we will not get into in this particular video and in this live stream. But suffice it to say, we have plenty to talk about. And to help me break it down and to help you understand and to learn about the law enforcement response and others, please welcome back inside the law our friend and yours, Oconee County Sheriff Scott Berry, retired after, I don't know what, Scott, 86 years as sheriff or something like that?
Something like that. It was 28, but thank you for aging me.
Yeah, and of course, Oconee County is nearby. And just tell us, Scott, since you were the chief law enforcement officer in a county very nearby there, this is in the Winder area, Barrow County. Explain to people who may not be familiar with our geography here in northern Georgia, explain where this all took place relative to maybe Atlanta and Athens.
If you know where Atlanta is, and you draw a line about 50 miles east, slightly northeast of Atlanta, you come to my neighboring county, Barrow County. And Apalachee would be on the southern end of Barrow County, close to Bethlehem, Georgia. And that's, again, very close to Oconee County, where I served for, like I said, 28 years.
All right. So, but you still have your fingers in the law enforcement community, and I know that you're getting ready to take office the first of the year as coroner.
Yes.
What are you currently doing in terms of your present law enforcement role?
My current role is that of a training officer for the Madison County, Georgia Sheriff's Office, and I went to Apalachee High School. After I heard reports of the shooting, I met with the sheriff. The sheriff's a very good friend of mine. I count on him to be one of my best friends. Yeah. We talked briefly. He was busy.
Yeah.
I found a chore for me to do, and I went about and did that chore, and I felt like I would help the sheriff the best I could. And but I did gather some information that I want to bring back to our SROs here in Madison County and our sheriff's office. And I think in the next couple of weeks I'll have a sit down with our people and talk to them about what I saw and things to be aware of when something like this happens.
Well, heaven forbid it ever happens again. I hope that never comes to fruition in reality for you. But let's talk about, how does law enforcement even train for something like this? I know that you have been involved in these trainings, but what goes into preparing for and actually responding to an active shooter situation like this?
After Columbine, my then chief deputy was named Jim Langston. And Gene and I watched Columbine unfold on TV. Columbine, I think, was 1999. And we looked at the failures we saw at Columbine, the failures to immediately go in and address and confront that shooter. And the idea of waiting for a SWAT team to show up and things like that, to us, just wasn't what we were going to do. Okay, first off, we don't even have a SWAT team. Most counties in Georgia don't. Okay, so what are we going to do? What is our response going to be? And we wrote what we titled Plan Sierra, S for school shootings, Sierra. And Gene authored this, and it was a rather remarkable foresight into the future, where in an active shooter situation, we expected our deputies to go in, confront that shooter immediately, and frankly, Phil, we would either go to the deputy's award ceremony or funeral. The deputies, we expected our deputies to risk their lives, to put their life on the line for school children and school teachers. Real simple, Phil.
Yeah, you get the idea is that you go to
You go
the threat.
to the sound
you go
of
to the threat
gunfire.
because when it hits the fan, so to speak, minutes and seconds literally make the difference. And so we don't have the luxury of having any first responders sort of hang around outside.
No, you don't. No, but nobody. In fact, the first time we drilled and trained for this, we had a whole scenario planned out. My deputy arrived in front of the school, got out of his patrol car, engaged him and killed the bad guy right then. And we didn't even get to go through the rest of our scenario. We had to stop, say, "Oh, well, we killed him too soon."
Yeah, in your scenario, right?
In our scenario, yeah.
Well,
yeah. And of course, those are some great guys. I had some great men and women that worked for me, and I had 100% confidence they would do the right thing.
Yeah. Well, and this is a situation that, I think you and I were texting and communicating some offline and almost in real time right after this happened, I guess. And what we noticed, and what was obvious from the news reports and the television coverage, was there was lots of law enforcement agencies. Now, the sheriff's office there is, it's the reputation's great, but I mean, it's limited in what it can do. I mean, when you have a major situation like this, it's sort of an all hands on deck, right? So you're going to have support from other agencies. Do you remember how many agencies? I know I saw at least 4 or 5.
Oh no, there's at least there was a lot more than that. We had Judd had all kinds of support from all kinds of different agencies, and the problem is you get such an influx of people, you've got to find a mission for them. And that was Judd's dilemma. I know Judd's not here to defend himself, but if Judd had a dilemma, it was too much help too soon. It was like drinking from a fire hose. And getting those people assigned to things that were truly helpful to him took a few minutes.
Well, we had state, right? We had the GBI. I saw the Georgia State Patrol.
GMA.
We had FBI. You said FEMA?
FBI, GMA. Had
Georgia Emergency Management.
Gwinnett Police, Gwinnett Sheriffs, Monroe PD, Loganville PD, again, troopers from all over. I was talking to one trooper, a friend of mine. He works out of Marietta, so he came up from North Atlanta to be of assistance to the sheriff, and see, in my mind, that's why I went there. I wanted to be assistant to the sheriff. What can I do to make his life easier?
Well, because by the time you got there, right? I mean, the
shooting was over.
The active part was over, but there's still a lot that has to happen. I mean, how do you go about, I guess, protecting the integrity of that kind of a crime scene so that investigators can go through it?
The sheriff had that well in control. The FBI and the GBI were they're the individuals I saw processing crime scene. Um, I don't think having the school completely shut down, locked down was the easy part. You had 1,900 children and God knows how many staff members out on the football field that needed to be interviewed.
Yeah, they're all potential witnesses.
Yeah, they're all potential witnesses. So you got to find out what they know, what text messages are going around the school, who knew what and when. And I mean, that's a monumental task for the sheriff. And you know, that just processing, collating and getting up all that information, all those names, all those phone numbers is just a monumental task. Of course, you've got to treat the wounded people that are there. You've got grievous injuries, and they all need to be seen to. They all need to be interviewed. They all need to be talked to. So you've got some people at Grady. You've got them at the Barrow County Hospital. You got them at the hospital in Athens. You've got to send investigative teams to all those places. Not only if doctors remove shell fragments or things like that, but you need to know what they know. And
yeah,
frankly,
because if that's something that people don't really think about, like, so if somebody goes to the hospital and they've been injured, right? And if there's a piece of, if there's a bullet in them or a bullet fragment, or if there's trace evidence, some law enforcement officers got to be there.
We got to be there to get that.
You got to you got to bag it and tag it, so to speak, right?
Yes.
To make sure it gets to the right place and it's processed by the crime lab or whoever else.
And then, of course, you've got the people processing electronic devices. You got tens or hundreds of cell phones that may have information on them. So how do you actually get that done? You've got to write search warrants for each one of those phones and for the information on the phone.
Now, hang on, let me pause you for a second. So, do you think they got a search warrant for everyone, or did some of these kids or individuals just agree and do what's called a consent search? Because law enforcement doesn't always have to have a warrant. One big way that they wouldn't have to is it's called a consent search, where somebody voluntarily allows law enforcement to go through the device. Do you think there was a lot of that?
Well, I'm sure there was a lot of that. I'm sure there's, hey, look at my phone, look at my phone. But the best way to get that evidence, Phil, and you know this, consent can be withdrawn.
Yeah.
Okay. Consent, people can forget they gave consent. Then you've got to argue consent. Okay. The best way, and you know this, Phil, you're a cop, you're a DA, get a warrant. When all else fails, get a warrant. And I know Judge Smith well enough to know that you want the best evidence. You want evidence that can't be fought over, or at least, easily fought over. Get a warrant. When in doubt, get a warrant.
So for those of you who might be just joining us, we're speaking with retired Sheriff Scott Berry, who's also currently a training officer for a sheriff's office near this incident location, and was also one of the not the very first responders, but a responder who participated in the law enforcement response. And so we're picking the sheriff's brain because he's forgotten more about law enforcement and procedure than I probably ever knew. So the idea to me as an attorney thinking about, and I've been a part-time or substitute judge before, and the thought of having to process a couple of thousand search warrants in a relatively short period of time, that suggests to me they're probably still doing it. They probably haven't finished getting warrants for all those phones and going through them and processing them. It's not like you can drop 2,000 search warrants right on a dime.
No, you can't.
All right, so let's take this as an opportunity, Sheriff. Explain to our viewers and listeners, in case they don't know, what is required for the issuance of a search warrant, and what does a law enforcement officer have to do? What hoops do they have to jump through to get one?
Well, first off, let's go back to the Fourth Amendment for just a minute. No warrant shall issue except upon probable cause. So police officer has to create what's called an affidavit. All right. And an affidavit is a sworn statement by that peace officer where he or she swears that they honestly believe, and they've got reasons to believe that they put in the affidavit that certain information exists. We're talking about cell phones right now, so let's limit it to a cell phone. So you've got to a superior court judge, not an inferior court judge or magistrate. You want to take that to a superior court judge, and a superior court judge will either issue or deny that search warrant based on the affidavit. You say, I want to see this phone because I've got these reasons to believe this is on it. And they have to be fruits, instrumentalities,
Evidence.
Yeah.
Fruits,
You
fruits
got
of
to
a
have
crime.
some information. You got to have some belief there's that information on that phone.
So there's probably a couple of thousand cell phones that are sitting in bags right now that have not yet been processed because maybe they're still working on getting a search warrant for them. So
I would suggest that's probably true.
yeah, and so we can imagine that. Well, when you respond to a crime scene at, say, a private residence, obviously the emergency response is one thing, but if you want to start searching that house and really digging in and processing it for trace evidence and other things, you're going to have to get a search warrant,
Yes.
even if you think the owner of the house is maybe a murder victim inside or is dead. So you're going to have to do that.
You don't know who has standing to object to you searching that house.
But what about when it's a public piece of property like a public school? Do you have to get a search warrant to process the school?
No.
Okay.
The person that has standing, that all involves standing to object. If you're in a public school and something happens in that public school, and you end up being charged with a crime, you don't have standing to object for the evidence they find in that.
Right. So in a lot of these questions I'm asking that, I feel like I know the answer to, but we're just kind of working through it. But there's also no expectation of privacy in a government building.
Right.
Now, it's my understanding that the school resource officers or officers who were present at the school responded and arrested the suspect, pretty quickly, but unfortunately not quite quickly enough. But nevertheless, so he surrendered to law enforcement and he was taken into custody. I know you weren't there; you weren't the one that did it. But what does that physical process look like when you're taking someone in custody who may have just committed some kind of a terrible act like this?
Well, the first thing, of course, you're going to do that at gunpoint, particularly if they're holding a rifle. You're gonna do it quick, fast, and in a hurry. You're gonna get cuffs on them, and you're gonna get them out of that school. You're gonna get them out of that school so you can get them someplace else to talk to them. That is, if they're alive or not bleeding from being shot. So, in this instance, they did not shoot Colt Gray. So they had him, and they had a perfect opportunity to take him back to the headquarters or choice of an interview room. I assume they would take him to an interview room that's audio and video recorded and get a statement from him if at all possible.
All right. So let's move in now to the charges. And we, unfortunately, because this is the platform that it is, we're not able to be to use graphic words that might otherwise apply. So we'll keep it as non-graphic and as possible, lest we risk being demonetized or something else on this view. But we can go ahead and move into the charges, and we want to first take a look at Georgia's. It's one of the crimes against the person. And we have a number of different ways that we could be potentially charged in Georgia with some type of murder. You've got what we call malice murder, which is, this is, I guess, Georgia, except for what we're about to talk about, Georgia doesn't really have degrees of murder. But in this sense, this would be essentially what might equate to first degree in some states. But this is called malice aforethought, and this is a legal phrase that goes all the way back to the common law. And so if a person, acts with malice aforethought, what does that mean? So that means that you have, it's more than an intention. Okay. It's like with an abandoned and a malignant heart, and the aforethought simply means premeditation. And premeditation, unlike what you might see in the movies, it doesn't mean that you sit around for days or weeks, making
it's not.
elaborate plans. It can be
No.
formed literally in an instant. And it's a question for a jury to decide. Now, in this case, as of right now, there are no, this is not what the defendant is charged with here. But part B here tells us express malice is the deliberate intention to take someone's life, right? Manifested by external circumstances capable of proof. And so this statute is drawn broadly enough so that really a juror or a jury can be the fact finder and can determine whether these circumstances appear. And here's the abandoned and malignant heart language that I was just referring to. But then we've got something called felony murder, which is where a person commits this offense when, in the commission of some other felony, they cause the death of another, irrespective of malice. And then the next part is the second degree murder, which we're going to talk to in a few minutes as it pertains to the father. So this is the Georgia law. Now, I want to switch to, if I can do this without being too clumsy, I want to switch to the actual charges against the alleged shooter here. So we're going to, let me take that file out. I'm going to add this other one. And we have, all right, there we go. So here we have this is what an arrest warrant looks like, at least some of them. This is kind of an older, I remember seeing this form for warrants going back decades and decades. It hasn't changed much over the years.
That's old school.
Yep.
Sure is.
Here you have, and even the case number, the warrant number is handwritten.
Right.
And if you see here, where I'm zooming in, this says Superior Court of Barrow County, Georgia. So in Georgia, we have different types of courts that handle criminal cases. The law says that any court that is a court of inquiry, and that even could be a coroner sometimes, Sheriff, when you become coroner, coroners can conduct inquests. So I was trained that technically a coroner can do it. I don't know if that happens very often, but a superior court is the sort of the highest level of our trial courts. And here you can see that it's Barrow County. So each county has its own superior courts. And so the venue for anything lies in the county where it's supposed to have occurred, right? They got the name of the defendant, Colt Gray. And the affidavit here is that you were just talking about an affidavit in the context of a search warrant, but the same thing applies for an arrest warrant. And so what this one says, it says Jason Smith, and that would be the law enforcement officer who swore out this warrant, right. Regardless of what his role might be, whether it's the lead case agent or just somebody who was, his job maybe have been to get the warrants done. Everybody's doing little different
Everybody's
things.
doing other things. That's right.
So this may or may not be the lead case agent, but in any event, law enforcement officer who says on oath that to the best of his knowledge or belief that Colt Gray did in the aforesaid county commit the offense to wit felony murder under 1651. And it says where it happened. That's the address of the school. They've taken out and redacted the names, of course. But it says the the underlying felony, because we talked about with felony murder, you've got to have this underlying felony that causes the death. So here it says during the commission of aggravated assault. And what I can tell you, I don't have the statute, but aggravated assault is essentially, it's Georgia's version of attempted murder, but it also includes assault with a deadly weapon. So if you shoot somebody, that's aggravated assault, whether they die or not, it's aggravated assault. So we've got it says that during the commission of that underlying crime, he caused the death of, and it says redacted, it would be the name, and it specifies that is a human being. And it goes on to say, while in possession of a black semi-automatic AR-style rifle fired in the direction of the redacted name, resulting in the projectile striking and causing death. So that's the affidavit. And then down here we can see this is a Superior Court judge who signed the affiant is the officer who would sign. The judge signed it, and then the judge would believe that that's suffices to at least hits all the elements of probable cause for the issuance of the warrant. And so the judge here signs the warrant, and here's literally what it says: to any sheriff or his or her deputy, coroner, constable, or marshal of said state, greetings. For sufficient causes made known to me in the above affidavit, you are hereby commanded to arrest the defendant named in the foregoing affidavit, charged by the prosecutor therein with the offense against the laws of the state as enunciated in said affidavit, and bring him/her before me or some other judicial officer of this state to be dealt with as the law directs. Herein fail not. Signed by Judge Mingledorf. And then you have a almost identical, it essentially is an identical affidavit for another charge of the same thing. And this is because you have different victims, right? So there's 4 of them, and they're all identical, and they're all charged him with the same type of felony murder. So I wanted to we'll leave that here for just a minute, because I want to talk to you, Sheriff. We talked about this earlier today. You and I did. We were talking offline. Why would maybe somebody, maybe a law enforcement officer under these circumstances, why would they not charge malice murder? And that's, it's kind of an academic question, because I'll go ahead and skip to the end. The penalty is the same. Okay. Under Georgia law, it's life or life without parole or death. But why would you not charge malice?
Well, I really don't know why. I think you got plenty of evidence for malice murder here. But my gut feeling is that this is the way the district attorney wanted it charged. And the district attorney's advice to the sheriff's office, the GBI agent, whoever this is, was, why don't we just charge felony murder? It's easy to prove. There's no need to try to prove malice. Okay. And it was a felony aggravated assault. You pointed a rifle at him, you killed him. It's as simple a murder. And I mean, I'm not making light of any of this, believe me, but it's the simplest way to charge a murder. It's a quick, dirty way to charge, not dirty in that regard, but it's quick paperwork, everything like that. There's no need to try to prove malice. And it gets him into court. Well, I think they'll clear all this up with an indictment.
Yeah, I was about to get to that. The district attorney, folks, is the individual in every judicial circuit in the state. Some counties have, if some, it's just one county is the entire circuit, and some smaller, less populated areas, you may have multi-county circuits. But the district attorney for the judicial circuit, will bring an indictment that will take the place of this warrant. This arrest warrant is a placeholder. It's what allows the sheriff of that county to hold this individual in jail, because without a warrant, it can't hold him. So this warrant allows him to be held in jail. The investigation continues. We've talked already about the mountains of work that still remain to be done. And then the district attorney will present another document, a draft of an indictment to a grand jury at some point in the future. And I would not be surprised to see other offenses charged. We're going to probably have aggravated assault against other individuals. We're going to probably have, we have laws against possessing firearms at schools. We have, so that's going to be in there. You've got other individuals who might be victims of other levels of crimes, and it wouldn't surprise me to see that this, the DA charged malice murder in addition to the felony murder. But in any event, that document, the indictment, will supersede and take the place of this arrest warrant. And by then, the DA will have had time to review the case file that's put together by law enforcement. I'm sure we'll have met with and talked with law enforcement at length about it, and they will make some strategic decisions about how they want to proceed. Now, before we move on to the father, we can't, and I don't have the video from the court hearing the other day, but he went for his initial appearance, which has to happen within a day or so. That's not really an evidentiary hearing, but that's where everybody who's charged with any kind of a crime, if they cannot or do not post bond, they have to be brought for what's called a first appearance, even if it's like a DUI, a misdemeanor.
In 48 hours.
Yeah. And it's usually quicker than that. So here he went before apparently that same judge who issued the warrant the next day, and they had the initial appearance. They set some additional court dates, and the judge advised him of what the range of punishments were. And in Georgia, for this offense, it's life or death. That's it. It's life or life without parole or potentially death. However, they brought him back in a second time. The judge had to correct something, and the judge had to correct that he's not facing the death penalty because
Bankston v. State.
Yeah.
And that was a case out of Park County where we when I was with the DA's office, we took that issue up with the Georgia Supreme Court, and they told us no.
Yeah, and also the U.S. Supreme Court has likewise said that it's we can't 14 years old and under 18, we can't seek the death penalty. So at the age of 14, though, people are asking, well, why he's a juvenile? And so under Georgia law, anyone who is 17 or older typically is who goes through the adult system. Under 17, so 16 and below, typically goes through juvenile court. However, we have certain offenses. They're called the 7 deadly sins. Can you name all 7?
Well, treason, hijacking, murder, rape, kidnapping, aggravated. I'm not sure what I can say on YouTube.
Yeah, let's leave it there. The real serious ones, right?
Yeah.
And those, the Superior Court has what's called original jurisdiction to deal with those. Now, there's a process that some of them can be transferred back down to juvenile court, but because of the nature of the offense and him being, if he were 13, this would not be the case. But at 14, he goes straight to adult court, and there's really, that's sort of the default setting. But I've been getting a lot of questions about that, so I wanted to go ahead and clear that up. Before we move on to the dad, let me just say welcome to all the 305 people now that are in here watching this live. We really appreciate you joining us, spending some of your Sunday with us. I wanted to point out we've got a new member. NGN 927 joined. Thank you very much. It's the memberships, it's the super chats, it's those types of things that help me to continue to make this kind of content and bring it to you, and hopefully in a little bit better every time. But newer and better content. It's this kind of support through the memberships, the super chats, and the support using the links below this video. Thank you in advance for any of those because that's really, really helpful to us to continue to do this. Also, the super chats they automatically put a star on my screen, so it brings this your question, if you have one, it brings it to our attention so that we can see it. And I've also got I know Kiana and some others are helping me star good questions, but there's a lot of you that are asking very good questions. So I wanted to take a minute to just address some of those early on. before we even started, Robin Brusso, I noticed before we went live, I noticed your question. And you pointed out that you're not convinced that the parents should be held accountable for the actions of their children. And so we're going to talk in a few minutes about the father and his charges and how those charges came to pass. And Robin, I had had a very similar conversation with my wife just the other night about this. And it's important to understand that the father is not being charged for the actions of his child. His warrants, as you'll see in a few minutes, charge him with crimes based on his alleged own actions, or in this case, his negligence, failure to act, or his negligent acts. So it's a little bit of an academic distinction. I know it feels like he's being charged based on what his son did, but when we get to the warrants, you'll see that his charges, Robin, are based on allegations of his conduct alone. Okay. So it's an important, but it's a great point, and I'm glad you asked it because it's going to lead us. It's a nice segue into the next piece of it, right?
I think, Phil, every parent with kids been in high school or middle school, things like that, have had this thought go through their mind. Is he being charged with something that his son did? And I think it's important we talk about at some point. No, he's being charged with something he did.
Yeah. Let's continue a little, get some of these questions out of the way. Carol's asking, why would a probable cause hearing be waived? Well, the probable cause hearing for both father and son have been scheduled for sometime in December. I forget the date exactly. It's a couple of months off, and that date can change. There are many reasons why probable cause could be waived. I think that in this kind of case, with at least with respect to the father, I doubt it's going to be waived, because that's the opportunity, the first opportunity for the defense in a criminal case to get some idea what the facts and circumstances are of their case. They don't have a right at this stage in the proceedings to what's called pretrial discovery. In Georgia, that happens after the indictment, and at some point prior to trial, the prosecutor's got to hand over essentially everything in their case file. But at this point, defense counsel, they're left to their own devices. A lot of times they've got a good collegial working relationship with law enforcement, so they may find out some of the things, but they need this information to help explore what direction their defense might go in. That's part of it. So that's one reason to have a probable cause hearing. But the technical legal reason that the right exists is so that it's like a screening mechanism, because if it's a case that doesn't need to be made, if there is not enough evidence, if there's not even probable cause to support the charges on the warrant, the judge has the opportunity to dismiss it. So you don't want people being held in jail if there's not enough legal reason to hold them there. So that's why we provide, that's part of the rights that are afforded to the accused. It's part of due process. So it is something that can be waived. Sometimes it is for strategic reasons, sometimes not in this case, but you might say to the DA, okay, look, we will agree to waive the probable cause hearing if you will agree to some kind of a bond for my client who's not been able to get out of jail. So there's a lot of reasons why it might be waived, and it might be waived if you just know that it's just going to be really, really, really bad. And you'd rather avoid the maybe creating some kind of a circus, or maybe to avoid even a media circus. That could be part of it. So, but we don't know if, we don't know if anything's going to be waived, but that's a great question. Thanks for asking it. I know Sheriff Berry never swore out a warrant that failed the probable cause test, but sometimes they do.
Yeah.
Sometimes they do.
They do.
All right. So, thanks, Carol, for that question. And then, we have, let's see here. All right. Bodie's asking the question, why is the dad being charged with only 2 counts of, all right. And so we're going to get into that. Okay. So
we're going to answer that question.
Yeah. we're definitely going to get into that. And I'm going to hold the answer for the extended discussion, but I wanted to acknowledge the question and thank you for asking it because it's a great one. This question here, Dr. Mimo says, is the father in jail or he's still in jail. He does not have a bond in either of these cases. At first appearance, there was technically at first appearance, the judge could set a bond, particularly if it's a superior court judge, they would have the legal authority to set bond. But in this case, there was no request was made because the lawyers that were there, they knew it was going to be denied, and they want to hold it for later when, if they want to make a bond request, when they can have a more meaningful evidentiary sort of a presentation. It's just too early. It's not the right time. But both of them obviously are still being held without bail. All right. So, Scott, I'm going to go ahead. If you have anything to add to that, now's the time while I'm looking for
No, I
the
think
next piece of this.
I think you've done a real good job as far as I'm concerned, explaining how the system actually works. And yeah, there we go.
All right. So here we have the Georgia law as it pertains to, well, crime. This is under crimes against the person. We have cruelty to children. There's different types. And we've got the first degree. Now, first degree regards parents, guardians, or other persons supervising kids, right? Under the age of 18. So we got first degree for those folks if they commit this offense as defined by the law, essentially the health and well-being being seriously jeopardized. Now we've got the penalty for. And that, again, that's another crime that is predicated on the concept of malice. They don't define it in the statute like they do in murder, but it's the same thing. It requires malice. And so the Part B refers to any person, not just the parents, guardians, or custodians, but any person who causes excessive physical or mental pain would be guilty of that type of first degree. Now, second degree is at the beginning of this live stream, for those of you who remember back to it, I said these charges against the father are grounded in criminal negligence. All right. So the statute says that cruelty to a child in second degree based on negligently causing a child under the age of 18 cruel or excessive physical or mental pain. And the penalty for someone who is convicted of that is not less than 1 nor more than 10 years. So keep that in mind because I'm about to switch back to the other statute. So we got to get rid of this guy. And I'm going to go back to the first. All right. We're back to the homicide statutes, and we're got all the way down here at the Part D. Person commits murder in the second degree when, in the commission of cruelty to children in the second degree, he or she causes the death of another human being, irrespective of malice. And it says that regardless of any malice, if there's the underlying offense of cruelty to a child in the second degree, if there's the death that occurs thereafter, then that would be the elements of that crime. And here it says the penalty for that is not less than 10 nor more than 30 years. So the question was, why were there only 2 of these counts? And so before we get into the answer to that question, Scott, I want you to tell us your best definition of what criminal negligence is while I pull up the warrants.
Criminal negligence to me is a reckless, abandoned, totally uncalled for, turning away from something that should be so obvious that it's going to cause somebody harm. I think that's kind of that's not a legal definition of criminal negligence, but I think that's a good everyday man walking around explanation of criminal negligence.
All right. So here we have the arrest warrants for the father, whose name is Colin Gray. Now, this arrest warrant, Scott, looks different than the other form. You
It
see
does.
how it's got a different sort of and there's really the difference is we're dealing here with a magistrate court warrant versus a superior court warrant. There's no rhyme nor reason to it. A lot of places have one form. In fact, in a lot of places, law enforcement goes almost exclusively to the magistrate courts for all arrest warrants. But it just so happens that they use a different form and it looks different. But here we have State of Georgia versus Colin Gray, and it says in custody here, so that when so nobody's going to go out and look for him, right? They're not going to be searching for somebody to arrest them, and since they're already in jail. This is a different officer. It says personally came Kelsey Ward. So they're splitting up their roles here. They're just it's all hands on deck. This is the affidavit, and it says that it says in the county and state aforesaid commit the offense of 1651D, murder in the second degree, to wit, they did willingly and knowingly, while in the commission of cruelty to a child in the second degree, Colin Gray did cause the death of, and it's redacted, a child under the age of 18, irrespective of malice, by providing a firearm to Colt Gray with knowledge that he was a threat to himself and others between the dates of September 4th, 2024 at 10 a.m. and 9/4/2024 at 11 a.m. in Barrow County. Place of occurrence being, and then it gives the address of the school. So that's the first charge. The second charge is another identical cruelty it says in the second degree. Sorry, murder in the second degree. That's the second charge. The third warrant is for involuntary manslaughter. He said it did willingly and knowingly while in the commission of reckless conduct, which is very similar to criminal negligence. Yep. Very similar concept here. Caused the death of an individual without any intention to do so by providing a firearm to Colt Gray. The same language as above. So that's an involuntary manslaughter. And again, it's based on recklessness, which is very similar to, and for our purposes, we'll just call it the same as criminal negligence. The next one charges him with another count of involuntary manslaughter with a different alleged victim. And then we have another involuntary manslaughter, which is worded the same way. And again, you have the presiding judge. It's completely different judge. I can't read the signature, but that's going to be a magistrate judge, right?
Right.
And so the language of these things goes, and it's identical to any sheriff, deputy sheriff, coroner, constable, marshal, or other law enforcement officer for sufficient causes made known to me in the above affidavit. And from other oral testimony given under oath, you're hereby commanded to arrest Colin Gray, the defendant named in the foregoing affidavit, charged by the prosecutor therein. It's a little bit different language, actually. And when they refer to prosecutor, they don't mean the district attorney. The prosecutor in this context is the law enforcement officer who
signed the affidavit.
Yep.
Yeah.
It says the offense against the laws of the state of Georgia as enunciated in this affidavit, and bring him or her before me or some other judicial officer to be dealt with as the law directs. All right.
So see over here, it says prosecutor. Phil should roll back up underneath where it says offense.
Oh, yeah.
15-3.
GBI.
GBI.
Yep.
Yeah.
Kelsey Ward, GBI. So the GBI brought this charge. And so this is another involuntary manslaughter for another alleged victim. And then we have here we have the actual charges, the underlying charge of cruelty to a child, and it's the same allegations. It says it did for a child under the age of 18 caused cruel and excessive physical pain by providing a firearm to Colt Gray with knowledge that he was a threat to himself and others between those same dates and at the same location. And I think this is the last one. This is another cruelty to a child in the second degree. The name is redacted, of course, but it's again the same allegations, and it's for all we know right now is it's for allegedly providing the firearm to Colt Gray with knowledge that he was a threat to himself and others between those dates. We have it's not the last one. We have another count of cruelty to a child in the second degree. Another count of cruelty in the second. The rest of the allegations, the language is the same. And then here's another one. I don't know if anybody else has lost count, but this is, these are all going to be essentially the same. Cruelty in the second. This would be for any child that was injured and not necessarily died, because we know there was at least how many injured?
Two that died, and I think there were total nine.
Yeah,
9 overall victims.
Yeah.
So
these will be the charges that pertain to survivors, but who were in. Yep. So that's how that works. And so when I say that they're grounded in criminal negligence, I'm going to cover up our faces just a minute, Scott. I'm sure that the people watching won't mind.
I bet they won't.
But we're going to take a look at. So this is Georgia law as it defines criminal negligence. First off, it defines a crime, and normally crimes, it says, or there's a joint operation. In other words, simultaneously, you have to have the criminal act. We call that the actus reus in Latin. And then a combination of that at the same time of criminal negligence. And we have intention to act or criminal negligence. And then criminal negligence is defined as an act or a failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Now, that's a lot of legalese. A lot of legalese. So the way I describe it to folks is, look, it's more than ordinary negligence, which is, you got a duty to use reasonable care to prevent foreseeable harm. So like if you've got a defective brakes on your car, you'd be negligent to go out and drive if you run a stop sign and that sort of thing. But this is more, and it's in the eye of the beholder, and that beholder ultimately might be a jury. It may be a question for the jury to decide if somebody acts with criminal negligence. So we were discussing this offline. I want to just throw this out there. Just from an academic perspective, if we're talking about somebody, in this case, the dad being criminally negligent, and therefore causing the cruelty to a child in the second degree, this statute for cruelty in the second degree that is bootstraps now into this new statute of second degree murder. It's relatively new in the state of Georgia.
Right. It is.
That law was designed. There was a high profile case out of Cobb County, Georgia, where a man was tried and convicted, but it later got reversed for a murder charge based on having left his child who died in the back of a hot car.
Right.
And so the statute was enacted to create a type of murder for situations like that, where the negligence, the criminal negligence, was directed by the defendant specifically at the child in question, and then the child in question dies. Here we have a couple of steps removed, right? And so if and we know from the clip that we showed at the very beginning, we know that the father had prior notice, because law enforcement went out there in the spring of 2023 and talked to him about some allegations that maybe the child had been making some threats at that time. So the allegation is that he later provided him with the firearm, and then we had this tragedy. So we don't have any direct connection between the father and any of the deceased victims here. So
Yeah.
we've got at least one level of removal. So it's going to be interesting to see if legally, and I'm talking about, a pure academic, legal academic question, if it's going to be interesting to see if those charges are going to, if they're going to stick. In other words, is a judge going to say, "Hey, wait a minute, Mr. DA, this is not what this law was intended for, and so we're not going to, we're going to toss this."
I see what you're saying, Phil, and I don't disagree with you. But the problem I have right now with taking it to that conclusion is we don't know what the GBI knows right now. We don't know what the sheriff knows right now.
Right.
And there's a lot of facts. They interviewed these people. They interviewed Colt and Colin, and we don't know what was said in the course of those interviews. We don't know what evidence the sheriff and the GBI and the FBI and everybody else was gathered. We do know, I think we know, that Colt Gray's mother called the school that morning. I mean, there is some evidence that Colt Gray's mother called the school that morning and said something's wrong with my boy, find him. And at least that's been reported in some other news sites. I'm not repeating that for the truth. I'm saying that's what the New York Post has reported. So, I mean, it looks to me like some adults at least had some idea that something was going on there. There you go.
Yeah. So
there you go. That's what I'm talking about right there, Phil.
Yeah. So it's being reported that on that day, the mother called and spoke to the school to warn of an, quote, extreme emergency. She spoke with a school counselor and reportedly urged them to immediately find her son to check on him. So all that's, this is all still, a big part of the facts and circumstances that have to be investigated. Want to share. Let's go ahead and remove this guy. Our mics will not be muted during this video.
More about what family members of.
So this is there's some news reports. Let's just drop in and see what some of this is about.
We are learning more about what family members of the accused shooter say happened Wednesday morning, right before the shooting. CBS News spoke with 14-year-old Colt Gray's maternal grandfather, who describes a text message the teen's mother received from her son.
Marcy got a text on the phone from Colt saying, "I'm sorry, Mother." And then we heard on the news of the shooting.
The Washington Post reports Colt Gray's mother called the school about 30 minutes before the shooting, warning a counselor about an extreme emergency involving her son. The suspect's grandfather says his wife even visited Apalachee High School the day before to talk with teachers about their grandson.
They were having some problems with him not going to school and this kind of thing.
The grandfather says Gray's mother lost custody of her children when she failed a drug test during a bitter custody dispute in recent years. Colt Gray and his father are both facing charges. They appeared in court for the first time Friday. Colt Gray, who was charged as an adult, faces murder charges, but prosecutors say expect more charges to come against him.
Yeah, and I agree. Look, we were talking about this. So that's, this is what is being reported. Usually the media is several steps behind law enforcement. So this is all going to be part of the investigation. And look, I'm not ruling out that, and law enforcement would not rule out maybe charging anybody else if the evidence and the investigation led in that direction. But look, let's make sure we talk about investigations. They're supposed to be objective pursuits of the truth. In other words, a good investigator is going to follow the evidence wherever it may lead, and then take any appropriate action without basically a preconceived or predetermined idea of.
I know Judge Smith. I know his Barrow County Sheriff's investigators.
Yep.
I've got 2,000% confidence that they are doing a good job. They're going to do the right thing, even if nobody's looking, and they're gonna use whatever evidence they can, present it to the district attorney, and let the chips fall where the chips fall. I know Judd that well.
Well, we're gonna obviously have to keep following this case. There's going to be other things that happen in this case that we can get back together here inside the law, and we can use it to learn something about. But I think everybody is in agreement that this is obviously a very sad situation. I can't imagine what it was like in, especially you and the law enforcement officers, the first responders, actually responding to something like this has just got to be a heart-wrenching experience.
Well, I was sheriff for 28 years, and the thing that I lost the most sleep over, the thing that kept me up at night, the thing that I went to bed worried about and woke up thinking about was, are our kids safe at school? I had a deputy killed directing traffic in front of a school, David Gilstrap, trying to make it safe for these car rider mamas and their children to get in and out of the school. I invested a lot of my life in those schools, and I'm still investing my life in schools. I'll be at schools all this week, and there's not a sheriff, there's not a peace officer, there's not an honest, law-abiding cop in this state that doesn't get up and think, I hope I'm up to the task of protecting those kids at schools today.
Well, we appreciate you, and we appreciate you spending the time here, and of course for your efforts on that day. I hope you'll come back here with us inside the law as this case moves forward. It's one of the ones that, we talk a lot about the Fannie Willis cases in Atlanta. We talk about the Koberger case out west, and we talk about the Donald Trump legal cases as they come up. We're going to have lots of opportunities here inside the law to explore these legal issues in the context of these cases that are in the news, and hopefully, we can continue to, I dare say, educate people, but at least give them the benefit of, my experience, and certainly people like yours and the other people that help us from time to time do this. So,
I think people have a very limited idea how things really work, Phil. And I think this show that you host and put a lot of effort into, goes a long way of letting people see what goes on behind the scenes of a real case. And
this comment here, Bodie says he, don't like to see viral misinformation, and there's a lot of it. There's just especially in legal cases, I see things all the time. The media misreports things. They just get it wrong. They don't describe something in accurate terms. And, that's what we're trying to clarify here.
Well, just as something as simple as the difference between burglary and robbery. I mean, the local papers rarely get that right.
Oh yeah. So, your house gets burglarized and they say you've been robbed, and one's a property crime and one's a crime against a person. Right?
Yeah, absolutely. So, I think I like this show, Phil. I like the format. Of course, I value our friendship, and I think this show can go a long way into helping people really understand what goes on, not just in Fulton County, because there's the rest of Georgia. Okay, there's the rest of us. Okay, out here in Georgia.
Well, I'd be happy for us to not have a whole lot more Georgia stuff to talk about. I was looking forward to talking about the Trump sentencing this month, and it's been put off. And then we've got we were going to do the Hunter Biden tax trial. And of course, he pleaded guilty because he's probably going to he's asking for a pardon, I'm sure. But and that's about as far as we're going to go with politics here. But we had some things that that we're going to keep keep following, and there's going to be other legal cases. Look, we still have the Fannie Willis, the disqualification stuff that's going on. Ashley
Oh, I
Murphy's
know.
arguing that before the Georgia Court of Appeals here in a couple of months. It'll be out after the election, but she's got a. I know you remember the Tara Grinstead murder case, right?
Oh, yes.
Which was a cold case. Well, it was a cold case for a long time here in the state of Georgia, out of South Georgia. And Ashley went down and represented the person. Actually, she and John represented him pro bono, and they won the murder trial. And then the DA brought some charges in another county. Ashley says those things are barred by the statute of limitations. But there's issues now about whether or not they actually are barred by the. And so she's getting ready to do oral argument here in the Georgia, I think, Court of Appeals later on this month. And so there's cases like that we can follow and we can still learn more about. So we just got lots to talk about.
That young lady, Lakin Riley, we talked about her before, Phil.
Yep.
She was murdered just miles from where I live. And, that case will come up, maybe probably not this year, not this calendar year, but certainly there'll be some advanced movement in that case in the next year or so. So
yeah,
that's one we want to watch.
There's never a shortage of cases that are going to be in the news for us to talk about. So, listen, I've kept you well over an hour, and I appreciate you being here. And I'd like for all the insiders to give a big round of applause to Sheriff Berry and say thanks. And let's welcome him back here whenever he's willing to come back. Will you?
Let me know, Phil. I'll come back happily.
Okay. Thanks, Sheriff. And, look, folks, I mean it. We're going to keep on this case. We're going to keep on the Lake and Raleigh case. We're going to keep on the YSL Young Thug. We're going to have, I'm sure, Doug and Rachel and anybody else. Ashley will be coming in soon. We're going to be having lots to talk about on lots of things. And so do me a favor, if you haven't already done it, please subscribe to this channel and tell anybody that you know who might be interested and may find value in this type of content. Ask them to subscribe to the show. Doesn't cost them anything. I'm approaching 50,000 subs, and I'm trying to, that's my next goal, is to hit 50,000. So help me out by telling anybody who might be interested in this kind of subject matter, might benefit, find it interesting. Please ask them to subscribe as well. And with that, I want to just say thanks to all of you. I've been watching the chat. I'm going to go and go back after I do this always, and I'll go back and I watch what goes on in the chat, what's said in the chat, and I try to learn from it. And I try to see what you guys are interested in, what you're talking about. And when you post comments in the after the post processing of these live shows, the comment section, feel free to comment there. I frequently go through those, and I wind up answering a lot of questions that are posed in that location as well. So, by all means, if I didn't address your question here live, ask it again. There's a good chance I might get to it and be able to answer it, or somebody else might answer it as well. That's another advantage to posting in the comment section after we're live. But with that, I want to say thanks again to everybody, and appreciate you spending part of your weekend with us. And we'll have to leave it there for right now, but I will see you back here next time inside the law.